Hello, everybody, and welcome to History/Law Bite number 329, dated December the 6th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you for tuning in today. This History/Law Bite is entitled Humphrey's Executor versus United States, 295 U.S. 602, 1935. Before I begin, however, I'd like to formally invite you to subscribe to my YouTube channel, Juarez Lee Shelton, M.A. And in addition to that, please also click on that little notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new, exciting, and enlightening videos in history, law, political science, theology, and philosophy. Thank you so much in advance. You're the best. So again, this video is entitled Humphrey's Executor versus United States, 1935. Humphrey's Executor is an important case on the issue of presidential power to remove executive officers of a quasi-legislative or quasi-judicial body purely for policy reasons and without the consent of the Congress. So it brings us to the facts. In 1925, William Humphrey was appointed by President Herbert Hoover to a 6-year term as a member of the Federal Trade Commission, the FTC. For those who are unaware, this body enforces U.S. antitrust laws and promotes consumer protection initiatives. In 1931, Humphrey was appointed by President Hoover to another 6-year term in his position. In the presidential election of 1932, Hoover was defeated by Democratic challenger Franklin D. Roosevelt, aka FDR, who soon found himself at odds with the conservative Humphrey on policy matters. In July of 1933, President Roosevelt formally asked Humphrey to resign from his position as a commissioner with the FTC. When the request was not acted upon, Roosevelt repeated this gesture in August of that year. Once more, Humphrey refused to step down, leading to his formal termination by President Roosevelt on October 7, 1933. Humphrey never accepted his termination and continued to insist that he was a member of the FTC and entitled to his $10,000 per year salary. His rationale was quite simple. The FTC Act only allowed for the termination of commissioners for, quote, inefficiency, neglect of duty, or malfeasance in office, end quote. Humphrey's termination met none of these criteria, but instead he was dismissed solely for policy reasons. As Humphrey died on February 14, 1934, all redress and litigation was pursued by the executor of his estate. It began with a suit filed in the United States Court of Claims seeking back pay from the date of Humphrey's termination, effective October 8, 1933, to the time of his death on the 14th of February, 1934. Likely deferring to the Supreme Court's decision in Myers v. United States, 1926, the Court of Claims certified 2 questions to the United States Supreme Court for review, which would be the basis of the issues for the justices to consider in this case. Oral argument took place on the 1st of May, 1935 at the Supreme Court, and attorneys for the petitioner contended that Humphrey's termination was unlawful according to the FTC Act of 1914. Once again, the act only permitted the president to terminate FTC members for, quote, inefficiency, neglect of duty, or malfeasance in office, end quote. Additionally, the Myers precedent was not applicable to this case, they argued, as the FTC was not a purely executive branch body, but rather was a quasi-legislative / judicial administrative body. Congress, therefore, had the authority to set conditions on the removal of its officers. Now, for reference purposes, the Myers versus United States decision, handed down just under a decade before this decision, had ruled that the president has exclusive power to terminate purely executive branch appointed officers. All right, Congress was not allowed to interfere with the president's ability to do that by setting specific conditions on their removal. That power specifically remained with the president. So Myers v. U.S. was a very pro-executive power decision, all right? And the attorneys for the petitioner here in Humphreys were arguing that this was a wholeheartedly different situation, and thus the Myers precedent did not apply because the FTC was not a purely executive branch body, but also had quasi-legislative and quasi-judicial administrative abilities. Okay? So, on the other side of the argument, the U.S. government contended that the section of the FTC Act in question here unconstitutionally interfered with the president's removal powers. They argued that the Myers case, like I said, which had endorsed strong removal powers for the president for purely executive branch officers, was most assuredly applicable here as well. Even though the FTC had quasi-legislative/judicial functions, it was still an executive branch agency whose officers were subject to the president's removal at his discretion. So the issues in this case are as follows. The court was faced with two specific questions, all right, certified by the Court of Claims, all right. The first question, do the provisions of Section 1 of the Federal Trade Commission Act stating that any commissioner may be removed by the president for inefficiency, neglect of duty, or malfeasance in office, restrict or limit the power of the president to remove a commissioner except upon one or more of the causes named? And question 2, if the power of the president to remove a commissioner is restricted or limited as shown by the foregoing interrogatory and the answer made thereto, is such a restriction or limitation valid under the Constitution of the United States? That takes us to the opinion of the court. The answer to both of those questions was yes and yes. On the 27th of May, 1935, the Supreme Court handed down a unanimous opinion authored by Justice George Sutherland in favor of Humphrey's Executor. Sustaining the constitutionality of the FTC Act and holding Humphrey's termination to be unlawful, the court rejected the government's argument that this case was controlled by Myers v. United States, 1926. That case, of course, had held that the president had exclusive power to remove executive officers that were entirely executive in function. In Myers, it was a postmaster general, for the record. In this case, Humphrey's Executor, the court ruled that the Constitution did not confer upon the president limitless removal power for all agencies. Humphreys was distinguished from Myers on the grounds that the FTC was a federal agency established by Congress with quasi-legislative and quasi-judicial functions. Therefore, Myers did not apply to the situation presented in Humphrey's Executor. So the summary baseline holding of the court in Humphrey's Executor versus United States was that the President of the United States does not possess limitless power under the Constitution to remove federal officers from agencies without purely executive functions. He may only remove executive officers from agencies created by Congress with quasi-legislative/judicial functions for reasons established by law. Justice Sutherland's opinion, therefore, contained the following points. Number 1, the Federal Trade Commission Act fixes the terms of the commissioners and provides that any commissioner may be removed by the president for inefficiency, neglect of duty, or malfeasance in office. It is held that the Congress intended to restrict the power of removal to one or more of those causes. Number 2, this construction of the act is confined by a consideration of the character of the commission, an independent, nonpartisan body of experts charged with duties neither political nor executive, but predominantly quasi-judicial and quasi-legislative, and by the legislative history of the act. Very important there. Number 3, when Congress provides for the appointment of officers whose functions, like those of the FTC commissioners, are of legislative and judicial quality rather than executive, and limits the grounds upon which they may be removed from office, the president has no constitutional power to remove them for reasons other than those so specified. Myers v. U.S. Limited and expressions in that opinion in part disapproved with respect to this case. The Myers case dealt with the removal of a postmaster, an executive officer restricted to executive functions and charged with no duty at all related to either the legislative or the judicial power. The actual decision in the Myers case finds support in the theory that such an officer is merely one of the units of the executive department, and hence inherently subject to the exclusive and illimitable power of removal by the chief executive, whose subordinate he is. That decision goes no farther than to include purely executive officers. The Federal Trade Commission, in contrast, is an administrative body created by Congress to carry into effect legislative policies embodied in the statute in accordance with the legislative standard therein prescribed, and to perform other specified duties as a legislative or as a judicial aid. Such a body cannot in any proper sense be characterized as an arm or an eye of the executive. Its duties are performed without executive leave, and in contemplation of the statute must be free from executive control. To the extent that it exercises any executive function, as distinguished from executive power in the constitutional sense, it does so in the discharge and effectuation of its quasi-legislative or quasi-judicial powers, or as an agency of the legislative or judicial departments of the government. Number 4, the authority of Congress in creating quasi-legislative or quasi-judicial agencies to require them to act in discharge of their duties independently of executive control cannot well be doubted, and that authority includes, as an appropriate incident, power to fix the period during which they shall continue in office, and to forbid their removal except for cause in the meantime. Number 5, the fundamental necessity of maintaining each of the 3 general departments of government entirely free from the control or coercive influence, direct or indirect, of either of the others has often been stressed and is hardly open to serious questions. So much is implied in the very fact that the separation of powers of these departments by the Constitution and in the rule which recognizes their essential co-equality. Number 6, whether the power of the president to remove an officer shall prevail over the authority of Congress to condition the power by fixing a definite term and precluding a removal except for cause will depend upon the character of that office. To the extent that between the decision in the Myers case, which sustains the unrestrictable power of the president to remove purely executive officers, and the present decision that such power does not extend to an office, such as that here involved, there shall remain a field of doubt. Such cases as may fall within it are left for future consideration and determination as they may arise. So the laws applied here were Article 1 and Article 2 of the U.S. Constitution, as well as the FTC Act of 1914. So, the legacy of this case is powerful. Humphrey's Executor remains, a very dynamic precedent in limiting presidential authority to remove appointed executive officers, who are not purely executive in function. Congress has the authority to set guidelines for the removal of such officers, and the president cannot override those guidelines. He is not a king. Remember that. Though significantly distinguished from Myers versus United States, 1926, this decision actually works concurrently with Myers, in my humble opinion, to clarify both the law and limitations on presidential removal power when it comes to executive appointees that have quasi-legislative and or quasi-judicial powers. Ironically, the decision's author, Justice George Sutherland, who wrote for unanimous court in Humphrey's, of course, was in the majority in Myers 9 years earlier, along with Justices Van Devanter, Pierce, and Stone. In his memoirs, Justice Robert Jackson, who served from 1941 to 1954 as an associate justice and one of the most brilliant men to ever sit on the Supreme Court, by the way, wrote that President Roosevelt was very annoyed with the court's decision in Humphrey's Executor, feeling that the decision had largely been rendered out of spite. So, that concludes this video, and I'll conclude with you all by reciting the bottom line base model holding of this decision, and that was that the President of the United States does not possess limitless power under the Constitution to remove federal officers from agencies that do not have purely executive functions. He may only remove executive officers from agencies created by Congress with quasi-legislative/judicial functions for reasons established by law, as was the case here with the FTC and the FTC Act of 1914. Okay? So again, that concludes this video. I thank you so much for listening. Hope you learned something valuable and hope you enjoyed the video. If you liked my video, please leave me a like. That would be greatly appreciated. And if you have not subscribed to my channel as of yet, please do so now. Juarez Lee Shelton, MA. In trying to build my YouTube page, your support means more than you will ever know. So I'll end with the timeless words of one of my teaching role models, Mr. George Feeney. Believe in yourself, dream, try, and do good. In my own words, of course, take care, stay safe out there, and I'll talk to you at the next video. Peace.